basis that was laid for the application is just that, the objects of the Law Society. But the matter had already proceeded up to this stage. It had been proceeded for quite some time. But it would still not have any difficulties with accommodating the Law Society. But would request at least they put in an application that we can consider and see what is being said by the Law Society. That's all, my lord.
My lord, that my learned colleague would not ask the Law Society to put in writing the objects of its existence, including assisting the courts, the government and the public in all matters regarding the rule of law, enforcement of the law, and more importantly, protection and upholding the rule of law in the country and assisting courts to enforce orders that are emanate from the courts. A preeminent member of the Law Society, and therefore we have a direct interest in the matters affecting our members, including, I believe, Mr. Mutembei.
And this is a matter of considerable concern to members of the public, and perhaps of more concern to the Law Society of Kenya. What is currently at stake now is that your sister, Lady Justice Amburile, made firm orders yesterday when we appeared before her, together with my learned friend, Mr. Harvey, and my learned friend, Mr. Lady Julie Soweto, that Mr. Miguna should be produced, should be set free.
At this stage, I don't want to really go into what is actually before us.
Yes, yes.
Because first of all, I even have a problem. I thought that this was a fresh matter. The only document that I have it before me are applications.
Yes, my lord.
So there seemed to be actually another file that was not actually brought before me.
No, my lord, if you give us an opportunity, we shall properly guide you.
Yes.
It's a matter you can handle.
Yes.
Knowing
because
you
I can see that actually my sister actually referred to certain rulings that have been made.
No, my lord, we shall assist you.
No, what I'm saying, I don't even have those rulings.
All right. Coming at 10:45, it has come up at 12 o'clock with Miguna Miguna in the court level.
Well, I don't know. He might be here. I don't know. That's what I want to hear.
Oh, I see. So, my
come
lord,
back at 10:45.
if Mr. Mutinda could probably shed light on that. I'm sure that Miguna is
Because as you can see, actually we are not comfortable in this country. Let us go to is available.
Yes.
Then we can go there.
Well, my lord, Mr. Miguna was supposed to have been set free yesterday.
Yes.
In other words, he should probably be standing there, or he should be sitting somewhere behind us. We don't have him. So let my land friends make sure that when we come here, they are with Mr. Miguna. He has been set free and is in the courtroom.
Of course, there's a court order that was issued here by my sister. So if that court order was served, Mr. Mutembei is aware of it.
Yes.
So we'll deal with it when we resume at 10:45.
10:45.
Yes.
Yes.
That's all for now. We'll deal with it after this. Thank you. Thank you.
On all the parties. And indeed, as a result of the service they effected, my two learned friends representing the state are here. And we would like to remind them respectfully of what the panel judge said. That Mr. Miguna is to be set free forthwith. That is upon service. He is then to appear before the Lordship this morning at 9 o'clock for further directions or orders of the court. My Lord, after the time I'm addressing you, Mr. Miguna has not been set free. Whatever they want to say to the court, we have no objection. I have a lot I would like to say to the court. But let them produce Miguna before this court first. Let them say what they want to say in presence of Miguna. And let me address your Lordship and say what I want to say in presence of Miguna. My Lord, we must respect and comply with the court orders. We have sung this hymn too many times. And at no stage has the state organs or agents complied at all. This time they must not be permitted to get away with it. It touches on the rule of law, which is very dear to us. It touches on the independence of the judiciary, which is very dear to us. My Lord, I have been at the bar a bit longer than most of the people here in this room. But there is one case I remember very well. Involved a judge called Schofield. Schofield made an order of the court that the state would not be allowed to address the court unless they produce the body of so and so, whether alive or dead. They did not comply. Schofield resigned as a matter of principle. We don't want to come to that stage where we have to say to our judges that if they cannot comply with your orders, please, you have no business sitting on the bench at all. And people like Hamino have no business addressing you at all. My Lord, that is all.
Until Mr. Miguna is present in court. My Lord, to make this position clear, I want to refer to a decision of the Court of Appeal which has some bearing to these proceedings. My Lord, there have been several orders made by your brother Justice Kimaru and his orders were subject to the proceedings in the appeal, in the application, or rather criminal application number 1 of 2018, which involves the same parties here present in court in relation to the same subject, Mr. Miguna Miguna. And, my lord, there had been several acts of disobedience of court orders. By the first, second, third, and fourth respondent, for which they were required to purge proceedings. Also, the respondents are already in contempt. In that they were required to deposit a valid passport of Mr. Miguna Miguna, but instead they deposited a perforated copy of the passport. But to come to the point, the law is very clear over the ages in several jurisdictions, including our own jurisdiction, that a contemner should never be given audience until and unless they purge the contempt. Undertaking in that case would lead to their impeachment. They are so clear that what they have done is so serious that it was likely to lead to their impeachment and removal from office. And yet they continue to be in contempt. My lord, on page 6, your brother Mr. Kimaru says, from the submissions made, it is clear to this court that there is an obvious contempt of the orders of this court and a deliberate attempt by state agency to subvert the rule of law. That is not an idle statement. And my lord, it is not only your brother Justice Kimaru, but the Court of Appeal also found or rested their decision on the fact that the respondents had been found to be in contempt. So, my lord, in these proceedings, what it's all about is not even about Mr. Miguna Miguna. It's about the authority of the court. It's the court which is on trial. Somebody who has blatantly disobeyed court orders wants to enjoy the privilege of addressing the court when they are in contempt. So, my lord, what we are saying is this. Because of this contumacious conduct, the respondents should not be had at all. We are talking about compounded contempt, and the orders have been attached to the application. the orders for which they have previously been in contempt. They are now in contempt of another order which was made yesterday. And Justice Kimaru was so kind to say, I don't want to punish you. I just wanted to give you an opportunity to purge the contempt. They are given another opportunity to purge the contempt by your sister, Justice Aburili, to produce Miguna in court. In fact, in our submissions, in fact, that order was sought as additional. I think it was resting upon other orders. But that has also now been disobeyed. So, my Lord, I associate my submissions with what Senior Dr. Hamino has said. And borrowing the words of my learned friend, Mr. Cliff Ombeta, which he used very effectively for your brother, Mr. Justice Kimaru. The words that Mr. Ombeta used to, that the court needs to bite. And Justice Kimaru bit, but it was not hard enough. So this court should bite harder. And that will be all, my Lord.
That under Article 159, 1, judicial authority is derived from the people and is exercised by the courts as such. Therefore, the contempt for which the respondents have been found to be guilty is not only contempt of the court, contempt of judicial authority, and contempt for the people of Kenya, and contempt for the Constitution. They should not be heard until they comply with the court orders. Jomo Kenyatta International Airport, at which Mr. Miguna is currently held, is within the territory of Kenya. They must bring him in accordance with the court orders. The court order is sufficient documentation for him to be brought here. We do not countenance any other requirements from the respondents until they comply. That's all.
You can say to them that you put off this matter for about an hour or so that they can bring Miguna to court and continue. You can say that to them. We would have no objection to that at all.
My Lord, I start by saying that I've listened to counsel for the petitioner or the applicant. And as an officer of this court, my Lord, I must point out that there is a lot of misrepresentation to the court. Firstly, my Lord, you are dealing with an application filed under petition number 51 of 2018. In all the references that have and orders that have been made to you, my Lord, no reference has been made to the orders of Justice Mwita, which were made in that petition, my Lord, petition 51. My Lord, that petition and the orders that the court made on the 26th of February were the ones which allowed the petitioner or the applicant to come back to the country. and indeed is coming back the other day, was pursuant to those orders. And we'll come and address to you, Your Lordship, on that.
You better go there.
I better go there. So, my Lord, before I get there, my Lord, let me say, one, in terms of service, we were served with the order very late yesterday. We got to know about it in the morning. It was some minutes to around 6 there, towards 7. This morning, we managed to get the application. We were not served with the application. That was before Justice Aburiri. And we contacted our clients, the Minister of Immigration. Our client, the ministry, is in the process of putting in substantive replies to this application, my Lord. And at the same time, my Lord, having looked at the application and the misrepresentations that are contained inside, we are also making an application to set aside the orders of Justice Aburiri.
Well, I'm just trying to say we're getting into an area of arrogance.
Arrogance is here, my Lord, in presenting or telling the court what we are doing in the process. I don't know. We should avoid the sideshows. My Lord, that application and the replies, the information I have is that they will be filed at about midday today. That is at noon. So, my Lord, my initial instructions were, number one, to seek for time until past the afternoon. So that the court can see the replies that we have put in and also see the application that we are making. Turning back, my Lord, to the orders, because, and this is, I'm saying this as an officer of the court. The orders of Justice Mwita, and they are before Your Lordship, they are attached to the application. At order number 4, the court said that the petitioner or the applicant be provided with travel documents to allow him to re-enter the country, or alternatively uses his Canadian passport.
But he's not addressing the merits. Yeah.
I'm not dealing with parties here. I've not come there.
Yes, my Lord.
I've come there.
Yes, my Lord.
There are only 2 issues here. The judge directed that the petition be brought before me this morning.
Yes, my Lord.
Where is the petition?
My Lord, the petitioner, as I indicated to the court, we are putting in applications which will explain where the petitioner is, the replies, which will explain where the petitioner is. He's still at JKIA, International Airport. He has not been processed to enter. And the reasons why that has not happened, my lord, they will be provided in the replies that will be before your lordship in a short while.
My lord,
Can council allow me, my lord, to finish? Because I sat here for like 15 minutes listening to him.
What is so difficult about bringing the petitioner here and telling the court that we give us some time to go and prepare the petition? What is so difficult about that?
Come again, my lord.
What's so difficult about bringing the petitioner here and asking the court that give us some time so that actually we can process whatever we are processing? What is so difficult about that?
I think the difficult, my lord, is even the processing itself. The processing itself. There are underlying factors which will be settled in the replies, my lord.
About presenting the petitioner before this court and then asking to do what you want to do. You don't believe that the court can't be able to grant you the order that we're seeking?
We can seek directions on that, my lord, and instructions on that.
This is what I want to know. What's so difficult about actually presenting the petition before the court as directed, and then now proceeding to actually make the request that you want to make, so that the court can consider, and if the court finds.
My lord, the difficulty, of course, the difficulty that we are having with the order is that, number one, and we are saying this, we are saying, of course, the rule of the law is you comply with a court order. If you are dissatisfied with it or aggrieved with it, you put in an application to set aside.
My lordship, may I intervene?
may I say, I'm the one in charge. Yeah.
Yes, my lord.
Because actually I don't understand what is so difficult about bringing the petitioner here and then telling me that, look, we are actually trying to process this ABCD. This court has the power to say that go with the petitioner back. You want to actually send back the petitioner to Canada and you convince the court to give an order. This court has the power to do so. So what is so difficult about bringing the petitioner before this court? And
the instructions were to make the application. Of course, we indicate to the court that we are making the application. If, my lord, you can grant us until past afternoon, we come with the application. And of course, we also come and take directions from you on.
So you see, even though you can't actually explain the difficulty.
The difficulty, my lord, is in the processing, because you see the petitioner or the applicant came from outside the country. The airport is a no man's land. International, under international law, my lord. He is required to be processed to enter the country. That has not happened, and that is the difficulty, my lord. That's the difficulty.
So you are telling me that if somebody actually commits a crime within the presence of the airport, this court has no power to direct that person be brought to court to be dealt with accordingly.
Yes, it does.
What's so difficult if actually you already made an order that the petition will be put before us so that we deal with it according to the law? What's so difficult about that?
My lord, we are saying that that order was made without with concealment of material facts, which we are saying, and which we want to lay bare before the court. It would only be fair, my lord, if you can at least grant us the time, at least you look at the material that we are laying before you, and at that time, my lord, you can make directions and orders.
What I'm asking you, if you bring the petitioner before this court, would your application be rendered superfluous? Would your application seeking to set aside the orders of the Uhuru be rendered superfluous just by bringing the petitioner before me?
To a large extent, my lord.
In what way?
To a large extent.
In what way?
In that the orders of Justice Mwita, my lord, which are before the court, and which are the basis of these other transactions, will not have been complied with.
I'm concerned about Judge Aburi's orders for now, and come to Judge Mwita's orders later. But for now,
but you see, my lord, the orders of Justice Aburiri flow from the orders of Justice Mwita. We cannot overlook the orders of Justice Mwita.
and you read the order of Judge Aburi. You read the order of Judge Aburi.
I've just seen it this morning, my lord.
Yes.
Yes, I've read
says
it.
that you avail the petitioner before the court in the morning.
The problem, my lord, is how will we comply with the orders of Justice Amboridi when the orders of Justice Mwita are being violated? That's the issue, my lord.
Anything else?
My lord, you are told that you should not hear the respondents. In that they are in contempt. My lord, that is not correct. We are not in contempt of the court. The processes and steps that are ongoing are in accordance with compliance with the orders of Justice Mwita, of which the respondents find difficulties with the applicant himself. My lord, the decision you are referred to, that is the Court of Appeal decision, it arose from the judgment of Justice Kimaru in proceedings for which the Attorney General was not a party. There was a yes, my lord. In that, before Justice Kimaru, there was a finding of contempt. And that was the reason why the Court of Appeal was saying it could not hear the respondents. You will find that, my lord, at page 13 to 14 of that decision which you are referred to. So those facts are not similar to what we have here, my lord, where we are saying we are not in contempt, and of course there is no finding that we are in contempt, and there is no reason why the court should not hear us. All that we are asking, my lord, is you give us an opportunity, we file our papers, and the application that will be accompanying those responses. And at least, my lord, we can convene here in the afternoon and we'll be ready to take any direction from yourself. Give us an opportunity, my lord, for the side of the government to also be heard in this matter. You've only heard from one side. So that would be all, my lord, for now.
Just to add that parties who are dissatisfied with court orders, their remedy lies in either setting aside those orders or in appeal. It is our request, Your Lordship, that you intervene, that this Honorable Court intervenes to secure the petitioner's liberty amongst other human rights. That will be all, Your Lordship.
When considering contempt of court proceedings, Your Lordship has got residual powers to convict any of the advocates appearing in the matter if it comes out very clearly that he has contributed to the contempt. In this particular case, I invite you, Your Lordship, to consider that very seriously as to whether the advocates appearing for those who have violated court orders cannot be punished.
My Lord, if you may allow me, the proceedings are referred to in this judgment at page 41 by the Court of Appeal. And the relevance of the orders in this case, or rather proceedings, vis-a-vis Mr. Kimaru's orders are also put in perspective.
With the said court orders, a party who leaves the court premises with an order of the court must be assured that complied with, court will, where the continued disobedience renders it impossible to proceed with the matter, deny the person in facilitate the petitioner's safe passage to this court, and I also direct the first, second, and third respondents to appear before this court at 2:30 p.m. in person for further orders, and those further orders to be made, their absence notwithstanding. Avoidance of doubt, agreed judge's orders must be complied with before 2:30 p.m. today. In the meantime, the respondents have denied right of audience before this court.
My Lord, just one small matter. You notice that the second respondent has since been promoted to the position of principal position is occupied by one Mr. Joseph Munyoki. In the circumstances, my Lord, I think we could be quite satisfied if Mr. Munyoki appeared, if the second respondent would not be in a position to come.
If the principal secretary in which ministry?
In the same.
Let him come.
Yeah, I think that would be better even. Yeah. Okay. Most obliged. We thank the court.
From Kinda, I will not accept affidavits, and I will not accept people coming here to stand. You have to appear before me in person.
Including Mr. Matiangi.
We're much obliged, Your Lordship. Thank you.
Yes, my lord.
My Lord, the law for contempt sorry, I'm told that it's possible they may be on the way. Probably if you could speak.
Yes, you made an order in the morning that Mr. Boynet and Mr. Matiangi together with Dr. Jalango appear before you. My instructions, this afternoon, Your Lordship, with utmost respect, is that all attempts have been made to reach them and inform them of the court order. But unfortunately, Your Lordship, they are not answering their phones, and we are reliably informed that they are at the recruits training school where there was a pass out today, and therefore, as at the time of coming back to court this afternoon, we have not been able to reach them, Your Lordship. And that is why they are not able to appear here today, but it is not in disregard of the court orders. That is the practical difficulty we've experienced in trying to reach them and inform them about the court order, Your Lordship.
Where is the petition?
Your Lordship, unfortunately, I'm not in a position to satisfactorily answer that particular question, Your Lordship.
When I gave the order in the morning, it was Mr. Mutina, I directed the petition of the here. Who is holding the petitioner?
Well, Your Lordship, from what I understand is that the petitioner is at the holding facility, immigration holding facility at the airport, Your Lordship.
Yes.
And I may not be...
Whose authority?
Your Lordship, I may not be in a position to really answer that question satisfactorily, and I therefore beg that perhaps maybe we could have this matter mentioned tomorrow to allow the respondents an opportunity to appear in person and probably answer those questions satisfactorily.
See, Mr. Dear, what I'm concerned about,
Yes.
first and foremost, is the presence of the... So either the court orders are not being transmitted to the person, or the person simply doesn't care.
We're not able to reach them on phone, and I'm told they are attending the pass-out parade, so probably that explains why we've not been able to reach them, Your Lordship.
The police is a chain of command.
That's okay, Your Lordship, yes.
Fortunately, when he came here, he must have come knowing what Mr. Mutinda was required to do. But he doesn't have that information.
This morning, when we appeared before you, Mr. Mutinda from Attorney General's office, whom I believe is a senior officer, legal officer, and another learned counsel appeared for the Honorable Attorney General. And my Lord, after some argument before you, the Lordship leaned backwards and made an order that the senior officers of the state, the three of them, the respondents, should appear before you. And above all, Miguna Miguna should be in court. Again, may I say, my Lord, those were fair, reasonable orders in search of fair administration of justice without a phone. But I discovered later on that I could not operate. I had to get one. So I now have a mobile. My Lord, it's assumed that any Kenyan now has a mobile. And particularly the state, my Lord, has got proper means of communication, quicker means of communication, to ensure that its policies, its business is not obstructed in any way at all. My Lord, the gentleman appearing for the Attorney General has not told us who instructed him to appear. But what is most appalling and most amazing it becomes very clear, it emerges very clearly, that no effort whatsoever was made to comply with your Lordship's order that Miguna and Miguna should be brought to the court. No telephone call was made to the officer in charge at Jomo Kenyatta International Airport to tell him that the court has made this order. Through our own intelligence, my Lord, we have come to learn that Miguna Miguna is held at toilet at Terminal 2, Jomo Kenyatta International Airport. What is so difficult to get in touch with him and to bring him before? With tremendous respect to the state, it is quite clear that a deliberate decision has been made somewhere not to comply with the orders of this court at all. My Lord, some of us have been in this matter of Miguna for too long. My learned friend, Senator Orengo, my learned friend, Honorable Otiende Amolo, my learned friend, Julie Soweto, my learned friend, and my Lord, Mr. Miguna Miguna would be quite right to look at me right in my eyes and say to me, Khamenwa, since you came into this matter, what have you obtained for me? We have obtained nothing for him at all. All the court orders that have been made have been flouted. My Lord, you remember my learned friend, Senator Orengo, was able to refer you to the jurisprudence of some of our other countries, including the common law country of the United States, where even the head of state was made to know that he is a lion under the law. He is a lion under the Constitution. Not very far away from us, our own sister country in South Africa, when the late Mandela was summoned by the court, he went running and appeared in court and bowed to the judge because he appreciated the importance of obeying court orders. He appreciated the importance of making sure that the rule of law is maintained in a country. My Lord, I can go on and say a lot of things. But before I sit down, I'd like to say this to your Lordship respectfully. My Lord, your hands are tied. There is absolutely nothing that you can do. Your hands are tied by the law and by the Constitution. There is no way you can bend backwards to accommodate the State Council that you put up this matter to do. You have to uphold the oath that you took when you were appointed a judge of the High Court of Kenya. That you will administer justice without favor and with courage. You have to proceed and issue appropriate orders involving sentencing those who have disobeyed the orders of this court for being guilty of contempt. That's the only way we can ensure that sense and the rule of law are maintained in the country. None of us is above the law. My Lord, I would not be speaking if the state had made an attempt to say to you that the senior officers are attending some other official matters, but here is Miguna Miguna in court. That would be a good mitigating fact and would be understandable. That has not been done at all. So, my Lord, we invite you very respectfully that you proceed to carry out your unpleasant task of making sure that you hand down appropriate sentence. My Lord, I did a little bit of research, not much so.
But they should be in a position as a substantive party to tell us why Mr. Miguna is not here. And the office of the Attorney General occupies a very fundamental and critical position in our constitutional arrangement of government. So on a matter of this nature, the Attorney General should be seen to be doing everything possible to uphold the rule of law. My Lord, in other jurisdictions, an Attorney General who misleads a government attracts some form of sanction. In other jurisdictions like England and the United States, because of the special place the Attorney General occupies in our constitutional arrangement, he should be seen to be doing more than just being a courier. And they enjoy such facility that they can reach anywhere within government institutions. They can go where the president is, they can go where Mr. Matiang'i is, and give advice. My Lord, I think that the court should also frown on the fact that Mr. Mutembei is not here. And my learned friends, being not quite aware of the orders that the court made earlier this morning, Mr. Odhiambo, to be in a better position to assist the court, especially on the question of the appearance of Mr. Miguna before the court. But my Lord, now to come to the substantive issue, I want to reiterate again that this is not really about Mr. Miguna. And my Lord, if you look at the Contempt of Court Act, which I have a copy for the court, and my Lord, this legislation has a special place in the administration of justice. Particularly if you look at the objects, my Lord. Section 3. The object of this act are the following, and all of them together and separately are important. A, to uphold the dignity and the authority of the court. To ensure compliance with the directions of the court. Ensure the observance and respect of due process of law. Preserve an effective and impartial system of justice. And to maintain public confidence in the administration of justice. Now, my Lord, just think of what an ordinary member of the public thinks of the court in view of these orders that have been made from February. From the 2nd of February up to now, every order made has been disobeyed. Why does an ordinary member of public who comes before the court think of the court? That's an important consideration for your Lordship to take into consideration. And the worst part of it, my Lord, you see from the Court of Appeal decision, that your brother, Mr. Justice Kimaru, sat on his chambers until 7:50 p.m., giving the state opportunity to comply with these orders. And even being misled that Mr. Miguna was around the court pressings. Only to realize later on that in the parlance of our state organs, when the court makes an order for a person to be presented at Milimani Court, he finds himself in Canada. It is easier for the government of the Republic of Kenya to take somebody to Canada than to bring him at Milimani Court from the airport. It's cheaper and easier for them to take somebody to Canada than to bring somebody before the court, which they have again demonstrated today. My Lord, Section 4 of the Contempt of Court Act, there is two categories of contempt: criminal and civil contempt. And I think in these proceedings we're dealing with civil contempt, which according to Section 4(1)(a) is willful disobedience of any judgment, decree, direction, order, or other process of the court. And my Lord, jurisdiction of the court is found in Section 5, which includes punishment for contempt on the face of the court. And my Lord, you'd find it most interestingly under Section 6, when it comes to the law of contempt, even a subordinate court has powers to willfully, that's Section 6C, willfully disobeys an order or direction of subordinate court. It's not just a power with the superior court, even at subordinate court. This is so fundamental, that authority, judicial authority, for it to be maintained, that all along from subordinate courts to superior courts, that power lies with the court. So, my Lord, I would invite your lordships to exercise the jurisdiction under Section 7 to deal summarily with the contempt which has been committed on the face of the court. And earlier this morning, there was no denial that there had been disobedience. In fact, Mr. Mutinda's understanding was, yes, we have disobeyed, but we are going to set it aside. Well, Lord, one time I appeared in a lighter note in a subordinate court, and a gentleman of 8 years old was charged with a sexual offense, and when he had been convicted, he told the court that I am an orphan at age 80. They're saying he's an orphan. We're in similar situation where the Kenya government is saying, you know, we can't do it. Yet they have all these powers, you know, vested in them. So, my Lord, the only limitation to that power is found on Section 3, subsection 3 of that section, that where there's contempt provided for under any other written law that is not in relation to this Contempt Act, then that must be done in accordance with Article 47 and Article 50. if it is any other act. But when it comes contempt under this law, then my lord can proceed summarily, and all that you need to do is to maintain a record of the proceedings, which, my lord, you've been keeping the records of these proceedings. So, my lord, without taking a lot of the court's time, we invite the court, because you so found in the morning that there's been disobedience, willful disobedience, and now it is multiple contempt upon another. We were talking about contempt of Justice Aburili's order yesterday. Now that has been compounded by contempt of your own orders. And this is now a pattern. It's systemic. And there were two orders: to make the petition appear, which they have not done, and for the four respondents to appear. And at 2:30, my lord, they were not even here at 2:30. We were here at 2:30. But I think at least that is excusable. My lord, when it comes to punishment, my lord, the punishment for contempt is for a maximum period of 6 months. And I believe in what my learned senior, Mr. Amin, was saying, that we really have no alternative. If you look at the record of the judgment of the Court of Appeal, the ruling, you know, Justice Kimaru really tried and said, I'm not punishing you, I'm giving you an opportunity to purge. Even purging the contempt, they were not able to do. This afternoon, my lord, you gave them opportunity to purge by bringing Mr. Miguna here. That they have not done. So, my lord, we invite you to so find and meet punishment, the maximum punishment of 6 months against Mr. Fred Okengo Matiangi. It's high time. He knows the consequences of not obeying court orders. And I think that day has come. On retired Major Gordon Kihalangwa, Director of Immigration, 6 months. Joseph Boynet, Inspector General of Police, 6 months. George Kinoti, Director of Criminal Investigation, 6 months. And my lord, in view of the special nature of these proceedings and the attendance of the Attorney General, there should be a sanction against the Attorney General. There should be a sanction against the Attorney General. In fact, if you had an effective Attorney General or the other office was working properly, this disobedience of court orders would not have arisen. So, my lord, I invite you that they should also have 6 months. And they are here. No, we want the substantive one. My lord, but in order to orders be made now, directed to the officer commanding Police Division, Jomo Kenyatta International Airport, who is the 6th respondent, to release Mr. Miguna forthwith. And if there are any complications, let them release him in the hands of the Kenya National Commission on Human Rights, who are parties to these proceedings. My lord, I want to finish by saying this, if your lordship would allow me. Mr. Miguna is not a criminal. He is not a thug. There are those who have been convicted of offenses and are able to leave this territory and come back. Mr. Miguna has a residence in Nairobi, which the police attacked. Mr. Miguna has a rural home, which is his birthplace in Nyando constituency in Kisumu County. He has got 2 addresses in Nairobi and in Nyando. Now, his address is a toilet in Terminal 2. For the last 72 hours, he has been making a living in a room in which all the lawyers have had no access, in a toilet in Terminal 2 at the Jomo Kenyatta International Airport, which in fact is inconveniencing passengers. So, my Lord, I beg you that another order be made that Mr. Miguna's lawyers should be able to reach him, to have access to him prior to his release, instead of deploying GSU officers all over to ensure that lawyers cannot be able to reach Mr. Miguna. My Lord, I will ask Mr. Otiende now to conclude.
In addition to all that my learned seniors have said, Dr. Miguna is a person in custody in Kenya within the meaning of Article 49. So not only, my Lord, have the respondents breached the express orders of this court, they have also defied Article 49(1)(f), which is sacrosanct, that no one, under any circumstances, is to be held in custody for more than 24 hours. We've hit the 72nd hour. Even if there was nothing else, my Lord, that alone would have been grave enough. My Lord, secondly, 25 and 28, my Lord. My Lord, I would urge that given the unique nature of the contempt in this matter, not only should you punish the respondents with a sentence of 6 months, but my Lord, you should go ahead and also impose the fine allowed under that section on each of them of 200,000 shillings, but with a rider that the money not to be paid from the public coffers, they bear and pay it individually, so that the abuse of public office may invite some element of pain on their persons. My Lord, thirdly, the contempt in this matter has been demonstrated. But it's not just contempt of court, my Lord. It is contempt for the court. My Lord, the petitioner in this matter is represented by about 14 advocates with a cumulative experience of 320 years. The bulk of which is taken by Malene Singh. The respondents have senior officers, some of whom were in court in other matters, including when you walked in. But they chose in the morning to send you Mr. Mutinda, who ranks average. But the two gentlemen who appeared before you then take cover and they allow young Mr. Odhiambo and his colleague who I sympathize with, because I doubt if they can hit 6 years cumulatively. That is contempt for this court. My Lord, they then tell you that they have no connection or understanding of what you said in the morning to the people who are here as advocates for the respondents in the morning, Mr. Mutinda and his colleague. They don't even say they are holding their brief. They say they act for the respondents. What level of contempt is that? But much more seriously, my Lord, they then tell you the reason the first, second, and third respondents are not in court is that they are attending a GSU pass-out parade. My Lord, what would the director of immigration be doing at a pass-out parade of a GSU cadets? Much more serious, my Lord, is I invite my Lord to take judicial notice. This is something that can be confirmed. That by 1 p.m., the media had reported that that parade was over more than 4 hours ago. To tell you at 3:30 p.m. that these persons cannot attend because they are attending the GSU parade is to belittle us, is to belittle this court. It is shameful, my Lord, and I feel ashamed as an officer of this court and a legislator that the law and the courts can be treated with such contempt. My Lord, that is now contempt on the face of the court under Section 25 of the Act, which empowers you to detain anyone who commits that kind of contempt and who is in court before the court rises to detention within the facilities of this court. And I think the time that Dr. Hamino contemplated in the morning may have come, when those sent to this court by people who hold this court in contempt must be made to pay, even as their clients are paying. My Lord, only to add lastly, that in addition to what Senator Rengo said, we as advocates have never been treated so contemptuously as we have in this matter of Dr. Miguna. My Lord, I do not boast those many years of experience. Mine are only 22 years. But I have never seen such contempt. We have been denied access to Dr. Miguna. He has been denied access by family. He has been denied access to medical attention. And when we sought to serve the persons holding him within the airport facilities with the court orders, public officers who ought to respect this court invited tones of GSU personnel fully clothed in combat gear and helmets as if we were going to hit them with the court order. My Lord, this is ongoing contempt, and as you meet sentence on Dr. Matiang'i, Dr. Kihalangwa, and Joseph Boynet, my Lord, I invite you, alongside the invitation extended by Senator Rengo, as you direct the orders to the officer in charge of Kenya airports, the police officer, my Lord, so that they do not also have any escape route. It may also be important, my Lord, that we include the chief immigration officer based at the Jomo Kenyatta International Airport. And any other person, whomsoever, who might hold the authority to release Dr. Miguna.
that the court must take the action to finish off on what my senior, Otienda Molo, had said, to empower the advocates, the court itself, to enforce the orders that it has issued. My Lord, it is not enough that the superior officers, that is Dr. Matiang'i, Major Kihalangwa, or Joseph Boynet, hide in their offices and refuse to obey orders. We ask that you extend the orders to the persons who right now are in possession or in custody of Dr. Miguna. It is time that every single Kenyan, public officer, state officer, or even that low-ranking police officer who claims to act under instruction to realize that they are within the reach of the law and that they too must take responsibility for their own actions. And so we need to be able to walk out of here with the comfort that no police officer, however low-ranking, will tell us they do not have authority to act. The Constitution is directed at every Kenyan. And so if anybody within the proximity of Dr. Miguna should disobey this court's orders, they too should be liable to sanction of the court orders. That way, they will not be able to hide under the banner of we are acting on instruction of our superiors. That will be all.
Maybe the first interested party may go first. The 1 o'clock news and the pass-out parade of the GSU had ended. That notwithstanding, they were served yesterday, as Mr. Mutinda confirmed, so that they ought to have known that priority shifted from the pass-out parade to court. So that they chose to go to the pass-out parade and not come to court is further demonstration of the low esteem and high contempt with which they hold you. And not just you, the court, but the people of Kenya under the Constitution. If you may refer, my Lord, to Article 244 of the Constitution, in terms of the functions of the National Police Service, one particular one, sub-article C, says they are required, the National Police Service shall comply with constitutional standards of human rights and fundamental freedoms. These court orders, the multitude of court orders that have been made in the hope that they would secure the liberty and freedom of Miguna Miguna. And therefore, it is in active disobedience to the Constitution that the persons have disregarded those court orders. Article 159, sub-article 2B, requires that as you exercise judicial authority, courts shall be guided by the principle of justice shall be done to all, irrespective of status. To Miguna, justice should be done to him irrespective of his status. government must also comply, the respondents must comply with these court orders and do justice irrespective of their status. It is not a choice they have to negotiate, and that's what the Court of Appeal said. And justice shall not be delayed. We have seen a lot that they have been, at every turn, delaying the obedience and compliance with the court order. And actually they have been showing that they are not willing nor ready to comply. What effectively their refusal to comply means to the common man, that little man in the market, is that court orders don't matter, or that if you are well connected with people in government, you are safe, you can also ignore courts. They are effectively eroding the authority of the court. I only wish if it would have been possible to hand higher penalties. Unfortunately, the framers of this statute, the Contempt of Court Act, may have been motivated to propose low sentences, partly because they knew that the greatest culprits of disobedience are people in government. I therefore urge your lordship to impose the highest possible sentence, that is the 6 months in custody in prison, and or in addition to the cash payments, fines paid from personal sources, which should not even, they shouldn't conduct arambes from their friends. That's all.
That is that those who are subordinates to the respondents cannot continue to advance the argument that we are obeying superior orders. Capture that, so that the subordinates will continue saying that I'm only obeying what my bosses have told me. They should be able to be made to know that they are still accountable to the law and they will be punished accordingly by the law. Thank you. That Miguna must continue to remain in Kenya and it must not be whisked away to Kisumu Ndogo in Dubai. It should be brought to
of our jurisdiction are empowered to interpret court orders. In this case, I wish to remind the public in general and executive in particular the views expressed by the Honorable J. Because of anxiety, because of the increasing trend by government ministers to behave has been questioned in court. Courts, unlike politically minded ministers, are neither guided by political expediency or popularity gimmicks. There's championing no competitive streets. This court must ensure that its orders are complied with. The matter before me is no longer a dispute between the parties, but has now reached the level where judicial powers are on trial. The dignity of this court is being questioned. This court cannot just fold its arms while the rest. First, second, and third respondents are by their conduct being contemptuous of the orders of this court, and they are convicted accordingly. The said respondents will appear before this court tomorrow at 10 a.m. for sentencing and further orders. In default of their appearance, this court will proceed to mete out appropriate sentences, their absence notwithstanding. It is hereby directed that the petitioner is not under any circumstances to be removed from the jurisdiction of this court. Instead, the petitioner is to be unconditional. This order binds not only the respondents, but also the officers under them in whose custody the petitioner has been placed. The petitioner's lawyers, and unless the petitioner is released forthwith, said respondents will not be granted a right of audience by this court tomorrow, and those will be the orders from now.
Can we get the copy of this?
In the next 5 minutes.
And my lord, could the AG be made to serve the orders in view of the circumstances?
This order is made in the presence of a legal representative
Yes.
of the respondents.
Yes.
They must ensure that the orders are complied with, and I've made it very clear
Thank you.
that tomorrow the respondent will not appear. I will proceed with sentencing.
Thank you.
I stand in.
Most of them.
Much obliged.
Permit me to say this.
There is no impunity.
And the court cannot be sitting in its
There is no impunity. Immunity from impunity. Melani was. And you cannot be deceived.
Because first of all, I even have a problem. I thought that this was a fresh matter. The only document that I have before me are applications. So there seemed to be actually another file that was not actually brought before me. Yes. Yes. Because I can see that actually my sister actually referred to certain rulings that have been made. No, what I'm saying, I don't even have those rulings. Yes. This is what I wanted to deal with first. Yes, I want to deal with that one first. And then we move to the next stage. There's Mr. Maweu, who is for another party. Yes. Yes. Any problem with the Mr. Ndubi's client being joined to these proceedings? Interest and taking into account the objectives of the Law Society of Kenya, it is my view that the Law Society ought to be joined to these proceedings. Accordingly, the oral application is hereby granted, and the Law Society of Kenya is hereby joined as an interested party. Now, I'll resume proceedings at 10:45 to enable us get a better courtroom and for me to actually get the other file. Yes, yes. Yes. Yes.
But we cannot proceed with this matter further unless the petitioner, Miguna Miguna, is the courtroom. In other words, my other friend Mr. Mutenda, my other friend Mr. Waidi, has to make sure that Mr. Miguna is your courtroom. And I would respectfully suggest that instead of even coming at 10:45, let us come up at 12 o'clock.
So we'll come back at 10:45.
Even Mr. Mutenda could probably
Yes.
shed light on that.
Yes.
So that Miguna is
Because as you can see, actually we are really not comfortable in this courtroom.
yes.
So we need to actually get a more spacious courtroom
Yes.
where
Some
people.
of us need more air.
Yes. That's why I thought that actually let's actually just take a short adjournment,
Yes.
so as we can actually get a spacious courtroom.
Yes.
My court assistant will be able to check whether Judge Mita's courtroom is available.
Yes.
Then we can go there.
Well, my lord, Mr. Miguna was supposed to have been set free yesterday.
Yes.
In other words, he should probably be standing there or he should be sitting somewhere.
Yes.
We don't have. So let my land friends make sure that when we come here, this man is
Of course, there's a court order that was issued here by my sister. So if that court order was served, Mr. Mutenda is aware of it.
Yes.
So we'll deal with it when we resume at 10:45.
10:45.
Yes.
Yes.
That's all for now. Kajuang, anything else? Yes. Yes. I place aside, we'll deal with it after this one. Yes. Thank you. Right.
We effected service. We remain most grateful to my land friend, Senators Orengo, Mr. Waikwa, and Cliff Ombete. They effected service last night on all the parties.
Yes.
And indeed, as a result of the service they effected, my two landed friends representing the state are here.
Know where the petitioner is. It's them who know where the petitioner is, so they need to actually tell the court where the petitioner is. So the only thing that I need to actually get from them is one, where the order has been complied with,
Yes.
and secondly, why they should be heard.
Yes. Thank you.
Yes, Mr. Mutenda.
Thank you, Madam.
Yes.
So, my lord, before I get there, my lord, let me say, one, in terms of service, we got to know about it in the morning. It was some minutes to around 6 there towards 7. This morning, we managed to get the application. We were not served with the application. That was before Justice agreed. I don't know what arrogance they say, my lord, in presenting or telling the court.
I've not come there.
Yes, my lord.
I'll come there.
Yes, my lord.
There are only two issues here. The judge directed that the petitioner be brought before me this morning.
Yes, my lord.
Where is the petitioner?
My lord, the petitioner, as I indicated to the court, we are putting in applications which will explain replies, which will explain where the petitioner is. He's still at JKIA, International Airport. He has not been processed to enter. And the reasons why that has not happened, my lord, they will be provided in the replies that will be before your lordship in a short while. Can council allow me, my lord, to finish? Because I sat here for like 15 minutes listening to it.
What is so difficult about bringing the petitioner here and telling the court that we give us some time to go and process the petitioner? What's so difficult about that?
Come again, my lord.
What's so difficult about bringing the petitioner here and asking the court that give us some time so that actually we can process whatever we are processing? What is so difficult about that?
I think the difficult, my lord, is even the processing itself. The processing itself. There are underlying factors which will be settled in the...
What is so difficult about presenting the petitioner before this court and then asking to do what you want to do? You don't believe that the court can't be able to grant you the orders that you are seeking?
We can seek directions on that, my lord, and instructions on that.
This is what I want to know. What's so difficult about actually presenting the petition before the court as directed, and then now proceeding to actually make the request that you want to make, so that the court can consider, and if the court finds...
My lord, the difficulty, of course, the difficulty that we are having with the order is that, number one, and we are saying this, we are saying, of course, the rule of the law is, you comply with a court order, if you are dissatisfied with it or agree with it, you put in an application to set aside.
My lordship, may I intervene?
No. May I say, I'm the one in charge. Yeah.
I still want to understand actually this Mr. Mutenda.
Yes, my lord.
Yeah, because actually I need to understand what is so difficult about actually bringing the petitioner here and then telling me that, look, we are actually trying to process this ABCD. This court has the power to say that go with the petitioner back. Bring the petitioner tomorrow. Even if actually you want to actually send back the petitioner to Canada and you convince the court to give an order, this court has the power to do so. So what is so difficult about bringing the petitioner before this court and then proceeding to make the application that you're making?
My lord, my instructions were to make the application.
Yes.
Indicate to the court that we are making the application.
Yes.
My lord, you can grant us until past afternoon. We come with the application, and of course we also come and take directions from you.
So you see, even you can't actually explain the difficulty.
The difficulty, my lord, is in the processing. Because you see, the petitioner or the applicant came from outside the country. The airport is a no man's land. International government. He is required to be processed to enter the country. That has not happened. And that is the difficulty, my lord. That is the difficulty.
Mr. Mutina, you are telling me that if somebody actually commits a crime within the precincts of the airport, this court has no power to direct that that person be brought to court to be dealt with accordingly.
Yes, it does.
So what's so difficult if actually you've already made an order that the petition will be brought before us so that we deal with him according to the law? What's so difficult about that?
My lord, we are saying that that order was made without concealment of material facts, which we are saying, and which we want to lay bare before the court. It would only be fair, my lord, if you can at least grant us the time, at least you look at the material that we are laying before you, and at that time, my lord, you can make the direction.
In other words, what I'm asking you, if you bring the petitioner before this court, would your application be rendered superfluous? Would your application seeking to set aside the orders of Judge Burili be rendered superfluous just by bringing the petitioner before me?
To a large extent, my lord.
In what way?
To a large extent.
In what way?
In that the orders of Justice Mwita, my lord, which are before the court, and which are the basis of these other transactions, will not have been complied with.
I'm concerned about Judge Burili's orders for now. I'll come to Judge Mwita's orders later. But for now...
But you see, my lord, the orders of Justice Burili flow from the orders of Justice Mwita. We cannot overlook the orders of Justice Mwita.
And you read the order of Judge Burili? You read the order of Judge Burili?
I've just seen it this morning.
Yes, you've read it. It says that you avail the petitioner before the court in the morning.
The problem, my lord, is how we will comply with the orders of Justice Burili when the orders of Justice Mwita are being violated. That's it. That's the issue.
Yes, anything else?
My lord, you are told that you should not hear the respondent. We are not in contempt of court. The processes and steps that are ongoing are in accordance with compliance with the orders of Justice Mwita, which the respondents find difficulties with the applicant himself.
Mr. Mawewu is in these proceedings. Does he want to say anything?
I associate myself with the submissions made by petitioners' advocates.
Yes, Dr. Amina, you want to say
My
something?
one small thing, but important, and which doesn't seem to be known by many lawyers at all. When considering contempt of court proceedings,
My Lord, if you may allow me, this
By counsel on this matter yesterday, that is the 27th of March 2018. This court, Burili J expressly directed that the petitioner, Mr. Miguna Miguna, be forthwith released to appear before this court today for inter partes submission of the petition and the application at 9 a.m. Before me, and that the application be served. It is not in doubt that the application and the order were duly served by last night. It is also clear that the order has not been complied with by the respondents, who contend that they need time to process the petitioner and to apply to set aside the said orders. In my view, the effect of the orders issued herein were to place the petitioner under the custody of this court unless further orders were issued. The issue of processing the applicant does not arise. I have listened to Mr. Mutida, learned counsel for the respondent, and nothing in his submission convinces me that there is any difficulty in complying with Aburili J's orders. Nothing stops the respondent from making the application notwithstanding compliance with the said court orders. A party who leaves the court premises with an order of the court must be assured that the same will be obeyed by those to whom it is directed, and unless the same is complied with, or for some reason the respondent satisfies the court that the order is incapable of being complied with, the court will, where the continued disobedience renders it impossible to proceed with the matter, deny the person in default audience. The court ordered that these proceedings do proceed in the presence of the petitioner. Unless and until the court varies the said order, the inter partes hearing cannot proceed due to actions or inactions of the respondent. It is therefore my view that the respondents have disobeyed the court orders as at now. However, as the order was served yesterday, I direct that this matter will be stood over to 2:30 p.m. today. I further direct that the respondents do facilitate the petitioner's safe passage to this court, and I also direct the first, second, and third respondents to appear before this court at 2:30 p.m. in person for further orders, and those further orders will be made their absence notwithstanding. For avoidance of doubt, Aburili J's orders must be complied with before 2:30 p.m. today. In the meantime, the respondents are denied right of audience before this court.
My Lord, just one small matter. You've noticed that the second respondent has since been promoted to the position of Principal Secretary, and that previous position is occupied by one Mr. Joseph Munyoki. In the circumstances, my Lord, I think we would be quite satisfied if Mr. Munyoki appeared, if the second respondent would not be in a position to come.
Is the Principal Secretary in which ministry?
In the same term.
So let him come.
Yeah, I think that will be better. Yeah. Okay. Most obliged. We thank the court.
Mr. Mutinda, I will not accept affidavits, and I will not accept people coming here to stand in their place. So they have to appear before me at 2:30 p.m. in person.
Including Mr. McCann.
We're much obliged, Your Lordship. Thank you.
Now for the other matter, the parties are ready?
Yes, my Lord.
Okay, can I come back in, let's say, 5 minutes?
5 minutes?
Yes.
Thank you, my Lord.
Yeah.
So can we get the quorum?
My Lord, the quorum is as before.
Those Mr. Mutinda, and I directed that the petitioner be here at 2:30. Who is holding the petitioner?
Well, Your Lordship, from what I understand is that the petitioner is at the holding facility, immigration holding facility at the airport, Your Lordship.
Yes. Under whose authority?
Leadership, I may not be in a position to really answer that question satisfactorily, and therefore they could perhaps maybe we could have this matter mentioned tomorrow. To allow the rest of the opportunity to appear in person to answer that question satisfactorily.
Yes, and about, first and foremost, is the presence of the petitioner before this court. Before the petitioner appears before this court, no amount of hearing by any party will assist. So if I gave an order, and that order was given yesterday by my sister yesterday, I said that actually you bring the petitioner this afternoon. Airport is actually not very far away. In this age and era, transmission of information, the person who is holding the petitioner cannot actually take that long. So either the court orders are not being transmitted to the person, or the person simply doesn't care.
In my previous explanation, we made all reasonable attempts to try and reach respective people, but as I've explained, leadership was not informed that that's okay.
So if you cannot get the Inspector General, there's a second person, and there's a third person. At least you could have told them that release the petitioner to appear in court. The minister or the cabinet secretary now has somebody called cabinet something secretary. Yes, he's supposed to be assistant. And apart from that, you have the permanent secretary or the principal secretary. And the principal secretary has also some people actually below him.
My Lord, another problem, if the Kenya was under attack, getting information to the Inspector General.
March 2018, Aburili J directed that the petitioner hearing Miguna Miguna before to be released to appear before this court today for mention of this matter. That order was not complied with by the respondents, who acknowledged that they were duly served and were aware of the court order. When this matter came before me this morning, I found as a fact that the respondents had failed to comply with the said order and directed that the order be complied with before 2:30 p.m. and that the first, second, and third respondents appear before me at that time. In the morning, when the matter was called out, Mr. Mutenda appeared for the respondents. However, in the afternoon, Mr. Mutenda was no longer appearing, and in his place were Mr. Odhiambo and Mr. Mnene. Mr. Odhiambo informed the court that the said respondents were attending a pass-out parade at the JSU recruit school and were unable to get in touch with them. There was, however, no explanation as to why the petitioner had not been released. It is therefore clear that there is completely no reason why the orders of this court have not been complied with. This court has afforded the first to third respondents an opportunity to show cause why they cannot be held in contempt, but they have decided to go into hiding instead. Article 10 of the Constitution provides as follows, and I've reproduced that particular article. In my view, obedience court orders is one of the tenets of the rule of law, and contempt of court would not be countenanced in a constitutional democracy such as ours, where the rule of law expressly stated in Article 10 to be one of the values and principles of governance that bind all state organs, state officers, public officers, and all persons whenever any of them inter alia and not applies or interprets any law or makes or implements public policy decisions. In Republic versus Combo and three others as parte Waweru, it was held, and I quote, "The rule of law has a number of different meanings and corollaries. Its primary meaning is that everything must be done according to law, applied to the powers of government. This requires that every government authority which does some act which would otherwise be wrong or which infringes a man's liberty must be able to justify its action as authorized by law. And nearly in every case, this will mean authorized directly or indirectly by an act of parliament. Every act of government power, that is to say, every act which affects the legal rights, duties, or liberties of any person, must be shown to have a strictly legal pedigree. The affected person may always resort to the courts of law, and if the legal pedigree is not found to be perfectly in order, the court will invalidate the act which he can safely disregard and quote. Mkule Jai in Muslims for Human Rights and another versus Inspector General for Police and 5 others express himself as follows, and I quote, "The principles of constitutionalism and the rule of law lie at the root of our system of government. It is a fundamental postulate of our constitutional architecture. The expression the rule of law conveys a sense of orderliness, of subjection to non-legal rules, of executive accountability to legal authority. At its very basic level, the rule of law vouchsafes to the citizens and residents of Kenya a stable, predictable, and ordered society in which to conduct its affairs. Like our national anthem says, it is our shield and defender for individuals from arbitrary state action." In Riverside versus Anderson, Lord Atkin held, and I quote, "In this country, amid the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. It has always been one of the pillars of freedom, one of the principles of liberty for which, on recent authority, we are now fighting, that the judges are no respecters of persons, stand between the subject and any attempted encroachment on his liberty by the executive, alert to see that any coercive action is justified by law," unquote. As was rightly stated in Republic as returning officer of Kamkunji constituency, it is the responsibility of the court to ensure that executive action is properly exercised. That Parliament intended that the High Court has the responsibility for maintenance of the rule of law, that there cannot be a gap in the application of the rule of law, that the court must at all times embrace a willingness to oversee executive action and to refuse to countenance behavior that threatens either basic human rights or the rule of law. Professor William Wade in administrative law states that, and I quote, "The judges with their eye on the long term and the rule of law have made it their business to preserve a deeper constitutional logic based on their repugnance to allowing any subordinate authority to obtain uncontrollable power." Unquote. It is in fact decreed in Article 4.2 of the Constitution that our republic is a multi-party democratic state founded on national values and principles of governance. It therefore follows that to disregard the said principles is to respect the very foundation upon which our republic is built. As was said by Musinga J. in Robert Kisiara and 3 others versus Officer Commanding Keyan General Service Unit, if we show disrespect to the supreme law of the land, casual observance would breach with impunity by the government or its servants, and fail to punish or penalize those who violate important provisions, we, as the Temple of Justice, will be encouraging such violation. Court orders, I must emphasize, are not subject to interpretation by the executive. Only courts of law issuing those orders or courts of higher jurisdiction are empowered to interpret court orders. In this case, I wish to remind the public in general and executive in particular the views expressed by Leonora J. in Karaoke and the 2 others versus Minister for Gender, Sports, Culture and Social Services as follows. The instant case is a cause of anxiety because of the increasing trend by government ministers to behave as if they are in competition with the courts as to who has more muscle in certain matters where their decisions have been questioned in court. Courts, unlike politically minded ministers, are neither guided by political expediency, popularity gimmicks, thirst championing, nor competitive streaks. Courts are guided and beholden to law and to law only. Where ministers, therefore, by their actions step outside the boundaries of law, courts have the constitutional mandate to bring them back to track, and that is all the courts do. Judicial review orders would otherwise have no meaning in our laws. Court orders must be obeyed whether one agrees with them or not. If one does not agree with an order, then he ought to move the court to discharge the same. To blatantly ignore it and expect the court to turn its eye away is to underestimate and belittle the purpose for which the courts are set up, unquote. The matter cannot be better expressed than the words of Ojwang J, as it then was in B versus the Attorney General, that the court would be exposed to ridicule, and no agency of the constitutional order would then be left in place to serve as a guarantee for legality and for the rights of all people. I also agree with the opinion Johnson versus Grant, cited in Trust Bank Limited, that the law does not exist to protect the personal dignity of judiciary or the private rights of parties or litigants. It is not the dignity of the court which is offended, it is the fundamental supremacy of the law which is challenged. As was said by Wasami J, as he then was in Mohammed Akhtar Khan versus the Attorney General. The new constitution has enshrined the Bill of Rights of all citizens, and to say one group cannot enjoy the rights enshrined under Bill of Rights is to perpetuate a fundamental breach of the Constitution and to legalize impunity at a very young stage of our Constitution. That kind of behavior, act or omission, is likely to have far and serious ramifications on the citizens of this country and the rulers, unquote. To paraphrase the judge, recent events in this country has evinced a clear indication that some people in the executive arm of this country have not tried to understand and appreciate the provisions of the Constitution of Kenya 2010. It also shows that yesteryear's impunity is still thriving in that arm of government, and that some members of the executive are behaving as if they are law unto themselves, and that the positions they occupy are their birthrights. They must know that the said positions are courtesy of the Constitution, which they must bow to, however powerful they are. I therefore agree with the position Jones versus Clinton, and I must send a strong message to those who are intent in disobeying court orders. Such conduct will not be tolerated, no matter the status of the contempt laws in society. When persons in authority themselves set out to disobey court orders with impunity, they must remember that they are sending wrong signals to ordinary Kenyans, and that it is proper to disobey court orders with impunity, which is a recipe for chaos. Such conduct must therefore be nipped in the bud as soon as it is detected. In my view, contempt of court is such a grotesque monster that the courts should hound it wherever it rears its ugly head and wherever it seeks to take cover behind any craft or innovation. As was held by the Court of Appeal Central Bank of Kenya versus Ratilal, judicial power in Kenya vests in the courts and other tribunals established under the Constitution, and that it is a fundamental tenet of the rule of law that court orders must be obeyed, and it is not open to any person or persons to choose whether or not to comply with or ignore such orders as directed to him or them by a court of law. Therefore, it is my view, and I so hold, that those who disobey court orders risk being declared by the court to have breached Article 10 of the Constitution, which prescribes national values and principles of governance with the attendant consequences, among other appropriate sanctions. It's therefore my view, and I so hold, that the courts are not only empowered to commit for contempt, but are under constitutional obligation to uphold the rule of law, and in doing so, to commit for contempt if the conduct of parties invites such a course. In this case, it is clear that the courts have been left babysitting its orders, while those to whom the orders are directed are carrying on their business unperturbed. That state of affairs cannot be permitted to continue. Those who disobey court orders must be made to answer for their actions or inactions. These court powers are derived from Article 13C and 159(1) of the Constitution. And quite apart from the contempt of court, this court as temple of justice must uphold the letter and spirit of the Constitution and must superintend its orders to ensure that the same are obeyed. This supervisory jurisdiction is not conferred under that particular act. Instead, in ensuring that the judicial powers and sovereignty of the people is upheld, the court must draw from its inherent powers. In the first American Bank of Kenya versus Gulab P. Sham, it was appreciated that the court is clothed with inherent powers and jurisdiction all the time, in all causes irrespective of legislative or other juridical foundations of any such cause or matter before it, as the juridical root of the cause inherent power lies in the nature of the High Court as a superior court of judicature. That the court retains residual power is no longer in dispute in the matter of the estate of George Mboroki, or Ukoje as he then was, expressed himself in the earlier as follows, and I quote, "It is therefore accepted that the court retains a residual source of power, which the court may draw upon as necessary whenever it is just or equitable to do so, in particular to ensure the observance of the due process of law and to prevent abuse of its process, to do justice between the parties and to secure a fair trial between them." Similarly, Kimaru J in Madara Evans Okanga versus Housing Finance Company held, and I quote, "The court will always invoke its inherent jurisdiction to prevent abuse of the due process of the court. The jurisdiction of the court, which is comprised within the term inherent, is that which enables it to fulfill itself properly and effectively as a court of law. The overriding feature of the inherent jurisdiction of the court is that it is part of procedural law, both civil and criminal, and not part of the substantive law. It is exercisable by summary process without plenary trial. It may be invoked not only in relation to parties in pending proceedings, but in relation to anyone, whether party or not, and in relation to matters not raised in litigation between the parties. It must be distinguished from the exercise of judicial discretion. It may be exercised even in circumstances governed by rules of the court. The inherent jurisdiction of the court enables the court to exercise control over a process by regulating its proceedings, by preventing abuse of the process, by compelling observance of the process. In sum, it may be said that the inherent jurisdiction of the court is a virile and viable doctrine that has been defined as being the reserve or fund of powers, a residual source of powers which the court may draw upon as necessary whenever it is just or equitable to do so, in particular to ensure the observance of the due process of law, to prevent improper vexation or oppression, to do justice between the parties and secure a fair trial between them." It is clear that unless compelled to do so, the respondents do not intend to obey court order or to obey orders of this court under any circumstances, but will instead continue doing so as long as no action is taken against them. I have stated before that it is time those who deliberately violate the Constitution despite being directed by courts take responsibility for their own actions. This court has had occasion to deal with the same issue in Judicial Review number 2 of 2014 between Kenya Country Bus Owners Association and others as Cabinet Secretary for Transport and Infrastructure, a matter which involved a member of the Cabinet, then Secretary for Transport, Engineer Michael Kamau, and the court expressed itself as follows. It is tried that in order to safeguard and preserve the dignity and authority of the court has powers to make any necessary orders, which in my view include an order that a particular public or state officer whose conduct the court finds reprehensible pays the cost of litigation. Such a decision, however, is an exception to the general rule, and the jurisdiction to do so is not to be invoked lightly. In my view, the taxpayers of this country will not be unduly burdened by being compelled to shoulder consequences of people whose actions contravene the Constitution, which is the social contract between the governors and the governed, and expect the people that the principles of the governors, on whose behalf the governors exercise sovereign power, to pay for the governors' sins. That there are cases where public officers may be held personally liable is appreciated by Kasango J. and Daneva Company Limited vs. Kenya National Highways Authority. I am guided by the decision the President of the Republic of South Africa vs. Office of the Public Protector and others, where the High Court of Pretoria, while penalizing the then South African head of state, that is Jacob Zuma, expressed itself as follows. My view is that in this case, a simple punitive court order is not appropriate. I say this because that would make the taxpayer liable for the costs. This is a case where this court would be justified in finding that this is an unwarranted instance for taxpayer to carry that burden. The conduct of the president and the context of the litigation he initiated requires a stern rebuke. There is not the slightest doubt that properly considered, the background of the matter and the circumstances of the litigation show that the president had no acceptable basis in law and in fact to have persisted with this litigation. In fact, the president's conduct amounts to an attempt to stymie the fulfillment of a constitutional obligation by the Office of the Public Protector. That court relied in the decision of Gauteng Gambling Board and another versus MEC for economic development. Finding made regarding the issues considered and discussed on this aspect can only result in one conclusion, that the president persisted with litigation and forced the intervening parties to incur costs in circumstances when this should and could have been avoided, as well as delaying the release of the report. In so doing, he clearly acted in flagrant disregard for constitutional duties of the public protector. What is so aggravating is the fact that the president's application was based on a self-created agency. Simply put, the president had become aware some 6 months before his abortive application that the public protector was in possession of the complaints implicating him in serious misconduct, and he did nothing when invited for comment. If that conduct falls outside the confines of the Constitution, more particularly Chapter 5 thereof, we fail to see how such conduct can be regarded as conduct of the head of state acting in his official capacity. In the final analysis, the president's overall conduct leaves me one option but to find that he must be held personally liable for all costs that were occasioned from 14th of October 2016. The president compounded matters when he persisted with litigation based on a supposed typing error after initially conceding the report be released if indeed the public protector had finalized the investigation and signed the report. That is not the only matter in which the same president was penalized in cost. Similar orders made by the South African Supreme Court of Appeal in Jacob Zuma versus Democratic Alliance and others. While this court is well aware of the provisions of Section 21(4) of the Government Proceedings Act, as well as the preamble to that particular act, it's this court's view that that act only applies to civil proceedings by and against the government. I have relied on the case of Welamondi versus Chairman Electoral Commission of Kenya to show that the matter before me is not a civil matter. I've also relied on the Council of Governors versus Senate and others on the same issue, as well as Macefield Trading versus Rushmore Company Limited, Muridi and others. It is therefore nothing barring the court in appropriate cases from holding an office of the government individual liable where the conduct of that office gives rise to circumstances under which it would be unjust and oppressive to subject the public to either pay money or costs arising for both. In other words, there is no immunity from impunity. This is what I would call the lifting of the veil of executive inscrutability and inoculation. For as Theodore Roosevelt, the 26th President of the United States, once said, and I quote, "No man is above the law, and no man is below it. Nor do we seek any man's permission to obey it. Obedience to the law is a demand as a right, not as a favor." Lord Denning similarly made it clear in Great versus Union of Post Office Workers and others that be you ever so high, the law is above you. As was held, the President of the Republic of South Africa versus Office of the Public Protector and others. This demonstrates that the other unavoidable finding one must make is that the President was grossly remiss in ignoring all indications from October 14, 2015. I am aware that this is not the first time the first respondent is being penalized to make payment personally by this court. That was the position in miscellaneous civil application number 546 of 2017. Having considered the issue raised before me, it is therefore my view and I hold that quite apart from contempt of court proceedings, this court must ensure that its orders are complied with. The matter before me is no longer a dispute between the parties, but has now reached the level where judicial powers are on trial, and the dignity of this court is being questioned. This court cannot just fold its arms while the respondents continue to cut work on its orders. The premises, I make the following orders. First, second, and third respondents have by their conduct been contemptuous of the orders of this court, and they are convicted accordingly. The said respondents will appear before this court tomorrow at 10 a.m. for sentencing and further orders. In default of their appearance, this court will proceed to mete out appropriate sentences, their absence notwithstanding. It is hereby directed that the petitioner is not under any circumstances to be removed from the jurisdiction of this court. Instead, the petitioner is to be unconditionally released forthwith to appear before this court tomorrow at 10 a.m. This order binds not only the respondents, but also the officers under them in whose custody the petitioner has been placed. The petitioner's lawyers are to be granted access to the petitioner. I, however, direct that unless the petitioner is released forthwith, said respondents will not be granted a right of audience by this court tomorrow, and those will be the orders for now. The ruling is ready. There are few typing mistakes I've noticed. In the next 5 minutes.
Listen, I've given immigration my card and refused to take the card. This is my Kenyan national I'm not boarding. I don't have a passport. I'm not boarding. I'm not going. Where are my luggage? Where is my passport? I'm not going anywhere. I'm not going anywhere. The captain cannot fly. Put that down. The captain cannot fly. Put that phone down. The captain cannot fly. The captain cannot fly. The captain. Because when I arrived, my lawyers came to meet with me. The Kenya National Human Rights Commission, as ordered by the court, and they took the document because they wanted me to have a safe passage. They were chased away, just away like beaten up and chased away. They just took these things and put in the car and started pushing people and tear gas and shooting at them. That's what they did. Look at them. They look like police officers. Where's the uniform? Where are their badges? Where are their names? I'm not boarding! I'm not boarding! I'm not boarding! I'm not boarding! I don't have a passport! I'm not boarding! I'm not going! Where are my luggage? Where is my passport? I'm not going anywhere! I'm not going anywhere! The captain cannot fly! The captain cannot fly! Put that phone down! The captain cannot fly! 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 The captain cannot The captain cannot fly, you have to kill me. The captain cannot fly. You cannot fly with me by force. I don't have a passport. You can't do that. My friend, I'm not going. You cannot take me from my country by force. Yes, so I'm not going. I'm not going. These are thugs. I'm not going. I'm not going. I don't have status in the Arab Emirates. I'm not going. This is my country of residence. This is my country of birth. You can't chase me away from my own country because you have guns. Kill me. I'm not going. I'm not going. I'm not afraid of you. I'm not afraid of your guns. Just kill me. I'm not going. I can't go to Dubai. To do what? I don't have status in Dubai. I'm not going to Dubai. The captain has legal obligations. There is no way the captain can take me to Dubai by force. There's no way. And I've said no. I am not going to Dubai. I'm not going to Dubai. I'm not going to Dubai. These are guys. Look at how they have torn my clothes. Yeah, they have torn my clothes. You know, I'm a lawyer. I have court orders telling them that they must process and facilitate my Kenyan citizen by birth. These are the court orders, read them.
Yeah, I mean,
these court orders say I must be in this country.
Okay.
Yeah.
Why are they not allowing you to?
Because of politics, they are scared of me. Now you, as a captain, is not allowed to fly me anywhere against my will. First of all, I don't have a passport. Secondly, I didn't book your plane. Thirdly, I don't have status in Dubai. So how am I going to go to Dubai? I don't live in Dubai. I don't work in Dubai. I have no connections to Dubai. So I'm not going to Dubai. Let them kill me. They're fine. Let them kill me. That's what they want. Let them go ahead and do it.
No, they're going to
but I'm not going to Dubai.
I've spoken to our management in Dubai, and they are going to get hold of immigration here to make sure that you don't come on this.
Yes. I don't want to come on this flight. I did not book it. They cannot chase me away like a pig when I have orders. I was born here. Some of these guys were not born here. They're just thugs that have been hired.
I understand that, sir.
And they have chased the media like rabbits. They're shooting at the... The powerful man in the hapa mtafungua. Bora yawe. Hata unataka kufungua. Hapa. Nilikuwa sasa ni waliotia tae. Nilikuwa bila kasa ni matuambia nini? Nilikuwa hapa kufungua. Nilikuwa wapi? Kufungua hapa. Nilikuambia nilikuwa hapa. Kufungua hapa. Nilikuwa hivi matatu. Tukaje hapa nakuja kuja. Hapa ndio mtatoa. Tunaenda na generali. You are going to kill us. Tunaenda na generali. Kwani ipo nini watu wanakuna? Mtahiga waende investment. Tunaenda na wewe fast. Ubaki hapa pale. Lazima uende
Kenya, unalala Kenya. Bwana Jogo kwa enforcement na yeye bwana.
Yes? What's going on now? So you're going to stay put tonight?
Very good.
One more question.
We will have one.
We will, and thank you for the mini interview. Yes, I appreciate it, sir. Thank you very much.
So don't worry. We are here for you.
Is continuing.
Yes.
We are just going to transform NRM into National Revolutionary Movement.
Yes.
National Revolutionary Movement.
Yes.
Going forward, no concessions, no surrender, no turning back.
Yes.
Surrender is not an option.
No surrender.
Guns are not issues.
Yes.
We are going to do this lunga lunga dance beautifully.
Yes. Umevutwa kazi. Afande. Usanse huyu. Jogidan lorne ya kome ya kaka kama mwenyewe makilongo ana. Songa pande. Yes. Yes.
Fanyeni chap bwana. Sana mbaya sana. Nataka kuanza kazi. Kutoka madhari ama jamaa anafanya nini?
hata wezi nitoa maarifa yangu raha.
That's you. Okay.
Members outside here, and so we continue to follow these unfolding events, and as and when Raila Odinga will emerge, we'll be able to know. So for now, let's listen in and get to hear what is transpiring right here outside the exit.
Officers grouped on one side. These are the officers who minutes ago have assaulted citizen TV reporters giving their tour. Business Wanjibi.
Oh no. Listen, I've given immigration my car and they refuse to take the car. This is my Kenyan national. I'm not boarding. I don't have a passport. I'm not boarding. I'm not going. Where are my luggage? Where is my passport? I'm not going anywhere. I'm not going anywhere. Oh. The captain cannot fly.
Put that down.
The captain cannot fly.
Put that phone down.
The captain cannot fly. The captain cannot fly. The captain. Because when I arrived, my lawyers came to meet with me with the Kenya National Human Rights Commission as ordered by the court, and they took the document because they wanted me to have a safe passage. They were chased away, just away like beaten up and chased away. They just took these things and put in the car.
I'm not boarding. I'm not boarding. I'm not boarding. I'm not boarding. I don't have a passport. I'm not boarding. I'm not going. Where are my luggage? Where is my passport? I'm not going anywhere. I'm not going anywhere. The captain cannot fly. The captain cannot fly. Put that foot down. The captain cannot fly. The captain cannot fly. The captain cannot fly. The captain cannot fly. You have to kill me. The captain cannot fly. You cannot fly with me by force. I don't have a passport. You can't do that. My friend, I'm not going. You cannot take me from my country by force. Yes, so I'm not going. I'm not going. These are thugs. I'm not going. I'm not going. I don't have status in the Arab Emirates. I'm not going. This is my country of residence. This is my country of birth. You can't chase me away from my own country because you have guns. Kill me. I'm not going. I'm not going. I'm not afraid of you. I'm not afraid of your guns. Just kill me. I'm not going. I can't go to Dubai. To do what? I don't have status in Dubai. I'm not going to Dubai. The captain has legal obligations. There is no way the captain can take me to Dubai by force. There's no way. And I've said no. I am not going to Dubai. I'm not going to Dubai. I'm not going to Dubai. Please apply. Look at how they have torn my clothes. Yeah, they have torn my clothes. You know, I'm a lawyer. I have court orders telling them that they must process and facilitate my Kenyan citizen by birth. These are the court orders, read them.
Yeah, I mean,
these court orders say I must be in this country.
Okay.
Yeah.
Why are they not allowing you into the country?
Because of politics, they are scared of me. Now you, as a captain, is not allowed to fly me anywhere against my will. First of all, I don't have a passport. Secondly, I didn't book your plane. Thirdly, I don't have status in Dubai. So how am I going to go to Dubai? I don't live in Dubai. I don't work in Dubai. I have no connections to Dubai. So I'm not going to Dubai. Let them kill me. They're fine. Let them kill me. That's what they want. Let them go ahead and do it.
No, they're going to offer.
But I'm not going to Dubai.
I've spoken to our management in Dubai, and they are going to give all the immigration here to make sure that you don't come on this.
Yes. I don't want to come on this flight. I did not book it. They cannot chase me away like a pig when I have orders. I was born here. Some of these guys are not born here. They are just thugs that have been hired.
I understand that, sir.
And they have chased the media like rabbits. They are shooting at them.
The powerful man in the world. Hapa mtapungua. Hata unataka kuangua. Hapa. Nilikuwa kasa ni waliotia tae. Nilikuwa bila kasa ni natuambia nini? Nilikuwa hapa. Nilikuwa wapi? fungua hapa. Tuambie ulikuwa hapa. Fungua hapa.
Wagini matatu.
Kuja hapa ndio mtu tuongea. Tunaenda na generali. You are going to kill us. Tunaenda na generali. Hapa laka wewe. Kwani ipo nini watu wanakuna? Mtahiza head investment. Right. Tunaenda na wewe fast. Ubaki hapa bwana. Lazima uende Kenya, unalala Kenya. Bwana ndio kwa enforcement ndio na yeye bwana.
Yes? What's going on right now? So you're going to stay close tonight?
Very good.
One more question.
We will have one.
We will, and thank you for the mini interview. Yes, I appreciate it, sir. Thank you very much.
So don't worry.
We are here for you.
Is continuing.
Yes.
We are just going to transform NRM into National Revolutionary Movement.
Yes.
National Revolutionary Movement.
Yes.
Going forward, no concessions, no surrender, no turning back.
Yes.
Surrender is not an option.
No surrender.
Guns are not issues.
Yes.
We are going to do this lunga dance beautifully.
Yes. Kwa mavuto wa kazi. Afande. Sanse huyu. Jogidan lor neja kome ya kapa. Kaja kwa mwenyewe makilongo ana. Songa pande.
Yes. Yes. Fanyeni chapcha bwana. Sana mbaya sana. Nataka kuanza kazi. Kutoka madhara ama jamaa anafanya nini? Hata wezi nitoa maarifa
That's you. Okay.
Members outside here, and so we continue to follow these unfolding events, and as and when Raila Odinga will emerge, we'll be able to know. So for now, let's listen in and get to hear what is transpiring right here outside the exit.
Officers grouped on one side. These are the officers who minutes ago have assaulted citizens, TV reporters, TV control, businessman Jimmy Wanjigi.